The presidential election petition filed by NASA leader Raila Odinga split the highest court in the land, with 2 of the 7 judges who sat to hear and determine the matter holding a different opinion.
I respectfully disagree with the decision of the majority.
I hereby record, without equivocation, my dissent from the judgment given by the numerical majority of the Supreme Court bench.
While Ojwang and Ndongo will within 21 days comprehensively outline reasons for their dissenting opinion on the validity of President Uhuru Kenyatta's re-election, they from the onset held that Odinga's petition did not raise sufficient grounds to overturn the declaration made by IEBC 20 days ago.
Much of the evidence which the majority opinion adopts is largely unascertained, apart from standing in contradiction to substantial, more credible evidence. It is clear to me beyond peradventure that there is not an iota of merit in invalidating the clear expression of the Kenyan people's democratic will, which was recorded on the 8th of August 2017.
It was not proved that the voters' will during the conduct of elections was so affected by any irregularities cited so as to place this court or the country in doubt as to what the result of the election was.
For the 2 judges, IEBC had passed the basic test of conducting a free, fair and credible presidential election, since eligible voters were availed an opportunity to exercise their democratic right in compliance with Article 38 of the Constitution. The petition, in their opinion, did not meet the threshold of setting aside the results.
Challenges are to be expected during the conduct of any election. However, those challenges that occurred in this instance, and in my opinion, none occurred deliberately or in bad faith.
For my part, I would dismiss in its entirety the petition which came up before us, as it was devoid of requisite supporting evidence, just as it did not rest upon the pillars of the Constitution, the ordinary law, or the pertinent elements inherent in the configuration of a democratic election.
The 2 dissenting judges in their verdict held that the people's choice at the ballot had not been affected.
There is substantial information showing that, by law, the conduct of the election should have been mainly manual and only partially electronic. Hardly any conclusive evidence has been adduced in this regard, which demonstrates such a manifestation of irregularity as to justify the invalidation of the election results.
The decision of the voter at the primary locale of the election, that is the polling station, was unchallenged. How then can a process used to transmit those results for tallying upset the will of the electorate?
For Ojwang and Ndongo, that regional and international observers had given the electoral exercise a thumbs up was an affirmation of a credible exercise.
Thank you.
Justices Jackton Boma Ojwang and Njoki and Ojwang were clearly outnumbered by their colleagues in the Supreme Court bench. While the majority have had their way and the minority their say, the bar has been set way high for IEBC and future Electoral Commission in the conduct of presidential elections that are free, fair, credible and verifiable. Francis Gashuri, Citizen TV, at the Supreme Court, Nairobi.